So again, thank you everybody for coming to day 2 of the celebration / conference. This morning's conversations have been incredibly informative and reinvigorating. Sorry. And so now it's my pleasure to introduce an amazing panel of folks who have strong connections with the law school. Before I do so, though, we've had the pleasure of hosting for the last 2 weeks 2 clinical law professors from the Chancellor College of Law in Malawi, Chikosa Banda and Kasima Muli, who today is their last day here. And so everything that you've done for us over these last 2 weeks, it's been a very nice exchange. So now we have this wonderful panel that will talk about this case, Martinez versus Holder. And how this happened was a couple of months ago we had a clinic meeting and we were talking about the conference, and then Professor Sweeney, Maureen Sweeney, was talking about this case in the Fourth Circuit. And she will tell you all about the case, the panel will tell you all about the case. And we kind of looked at each other, and Lee Goodmark said, that would be a perfect lunchtime conversation for this conference. And so that's how this started. So Professor Sweeney has taught the immigration clinic here since 2004. She also teaches a crimmigration legal theory and practice course. She's a remarkable and imaginative lawyer who consistently presents novel legal theories, and she gets results through these theories, and she applies the same skills and discipline to her scholarship. And she'll tell you about this case and also about the work I think is going to come out, this collaboration they have with the Office of the Public Defender. We are also particularly pleased to have, I'm going to go work my way back, with Lauren Gold, who is a third-year law student here. She's the president of the Immigration Law and Policy Association. She's currently in the immigration clinic. She was a reporter for a decade, I believe, before coming to law school. So we very much thank you for taking the time out of all your studies to hang out with us on this Friday afternoon.
Your clinic work.
And all your great clinic work, yeah. Alison Yoder, who just graduated last spring. She was a staff editor with the Maryland Law Review. She was a leadership scholar. She was the president of the student chapter of the Maryland Lawyers Guild. She's currently clerking with the Juvenile Division of the Baltimore City Circuit Court. This fall, she will be joining DOJ. She's a DOJ honors. She'll be in the DOJ honors program, working in the immigration court in New York City. So we have to give a round of applause to DOJ. And then we have Emily Datnoff, who graduated here in 2008. She truly was a force during her time in the law school. She won a clinic litigation award for her work in the immigration clinic. She was a senior articles editor for the Journal of Healthcare, but she has been even a greater force since graduating in 2008. Upon her graduation, she clerked for the Maryland Court of Special Appeals, but that same year, the Maryland Immigration Rights Coalition was formed, and through her work with the coalition, she received an OSI Baltimore Community Fellowship with the Open Society Institute, and through the fellowship, she worked with the Office of the Public Defender to provide immigration-related advice about criminal convictions in light of Padilla versus Kentucky, and she's currently an assistant public defender at the Office of the Public Defender in Baltimore County. So let you all take it away. Thank you.
Well, thank you all. I'm going to provide a little context and then really let these folks talk. So our case is called Martinez versus Holder. It's a published decision from the Fourth Circuit. That is not typical for our clinic. What our clinic generally does is the very important and life-changing day-to-day deportation defense work in our immigration court right down the street here. But we also, being here at Maryland, take our cues from our clients and what their needs are. And this particular client needed to file a petition for review in the Fourth Circuit because he lost at the immigration court and he lost with the Board of Immigration Appeals. But we thought it was an important issue. His life is literally on the line. And it's also an important issue for purposes of the development of the law, the development of our asylum law. And so I took the urging of a couple of people to go ahead and take the case up to the next level. We certainly have had cases that we didn't win before, and I've always referred out those appeals, but this time with a little urging from Andre Davis, who teaches adjunct here and is a judge on the Fourth Circuit, and also a former student, Hillary Skolton, who now works at the Board of Immigration Appeals. She was pushing me along, and so I was willing to go with that, and decided to take the case to the next level. I'm going to let these guys give the history of the case, but I just wanted to give a little bit of context for what the facts are and what the legal issue is, though I know that that's not the focus here. Our client, Julio Martinez, is a 34-year-old now, I think. We've been with him for a few years, so like all of us, he's getting older. A 34-year-old, he has lived in the United States since he was 19 years old. When he was a young teenager, about 14, fell in with a group of guys from his neighborhood into a local kind of group or gang, which ended up being drawn into the much more dangerous and much larger MS-13 gang, which is one of the really dangerous Central American gangs. That happened when people were deported from the United States. Gang members were deported from the United States and took over what was going on down there, and then ended up taking over whole towns in El Salvador. If you know some of the context, the gangs are incredibly powerful and incredibly dangerous. So he got kind of pulled into this through this group of kids that he was hanging out with. But from the very beginning, refused to participate in the violent preying on the community that was the stock and trade of the gang, of the MS-13 gang. And so he resisted that. He refused to extort people. He refused to engage in the violence. He ended up getting beat up himself repeatedly for this, and finally decided to leave the gang, even though he knew that that was going to put his life in danger, because you're not allowed to leave the gangs. That's one way that they exert their power, is by making sure that nobody leaves and that nobody becomes a voice against them. So he did leave, and he's a very very straightforward kind of person. He tells you what he thinks. So when the gang leaders came to him and said, you know, what's going on, he said, I'm leaving. And they tried to kill him 3 times. Twice they almost succeeded, left him for dead on the street. And he finally, after trying to move within El Salvador, finally decided he had to leave the country or he's going to get killed. So he came to the United States. And he lived here for 12 years before he got put into these deportation proceedings where we ended up finding him. And, you know, kept his head down and basically stayed out of trouble. There was a little, you know, substance issue at one point. But other than that, he stayed out of trouble. He had no associations with gangs at all. And that's kind of when we ran into him. In 2011, he was put into deportation proceedings by the federal government. And so we represented him in a claim that his life was threatened because he had left the gang. The government took the position that anything associated with a gang could not provide the basis for an asylum claim. So you couldn't claim protection on the basis of this past association with a criminal gang. We took the position that the renunciation of that gang was something that could be the basis for protection, and that was not contrary to the principles of U.S. humanitarian law. So that's, and the Fourth Circuit ended up agreeing with us. Yay! So we actually got a great published decision and a really positive, very strong decision. And the Fourth Circuit joined the Sixth and Seventh Circuits, which had come to similar decisions. The First Circuit has actually gone the other way. So this issue could end up in the Supreme Court one day. But it's part of a national conversation. The other thing that complicates the conversation and makes it very interesting for those of us who do legal work is that the Board of Immigration Appeals, which is the agency, the final decision maker within the agency, 2 weeks after our decision from the Fourth Circuit, issued a decision finding that former gang members could not present a claim for asylum. So the agency has taken the opposite position, which means that I'm not going to be out of a job anytime soon. This is going to go on for a while. And during all of this, our client has been detained. He's been detained for 2.5 years now. He has kids. He has 5-year-old twins who are the apple of his eye, and he hasn't seen them in over 2.5 years. So that continues to weigh on all of us and continues to inform our advocacy in the case. That's really, as you will hear, what we're working on now. So I'm going to stop talking now and let these three sort of give a history of how the case developed and the different kinds of advocacy that we did. One of the wonderful things about the case for me has been the community that has built around the case, and you'll hear some more about that, but these three are certainly at the heart of it. So I guess we'll start with Emily, who was an OSI fellow, and she can explain a little more about what her project was and how she encountered Julio and referred the case to us, actually.
All right, so I met Julio as an OSI fellow. I received the fellowship basically because of Maureen Sweeney. She had very close ties with the Public Defender's Office, and there was a program in the making there where they wanted an immigration expert to provide immigration advice on the immigration consequences to non-citizen clients. And I was a student in her clinic, and I just loved immigration law. I really tried to get into immigration law after graduation, but for some reason, no immigration law organizations wanted me, so I ended up working for a law firm, a really good law firm, but it just wasn't what I wanted to do. So through my work with the Maryland Immigrant Rights Coalition, which Maureen Sweeney was the president of at the time, the organization was talking about submitting a project proposal for an OSI fellow, and I was like, I'll do it. And so I got the fellowship, and I started working at the Office of the Public Defender. And so my project it had two goals. It was to provide, to kind of work as an immigration consultant with public defenders, advising them on the immigration consequences of convictions, basically what a client could plead to keep from subjecting them to deportation. And then the other part of my project was to actually provide direct representation to non-citizen clients once the criminal matter had been resolved. So once we worked really hard to preserve eligibility for immigration relief, a lot of times the clients from the criminal justice system would transfer into the immigration system. They'd be subject to removal proceedings, but they would go in without representation. So for a very limited number of clients, I would follow their case in immigration court. So I had just started my fellowship, and I was completely new to immigration law, being an immigration attorney by myself. Like, I'd only done immigration work in the clinic, and I had naively already picked up 5 cases, and and I was just completely inundated and overwhelmed. And I went to Dorchester. So immigration, or ICE, Immigration Customs Enforcement, they contract with county jails to house immigration detainees, and so at the time, one of the jails that they had contracted with was Dorchester County Detention Center. So I was going there to meet with, I went there with the attorney from the post-conviction unit to meet with a client, and Julio Martinez had written her, and we were going to meet with him because he initially wrote her to do post-conviction work. I can't remember what it was for. So that's how I met him. And when I first met him, he had no idea what was going on, and neither did I. He had all this paperwork. He told me he had something called temporary protected status, that he had worked for the government as an informant, that he had paperwork that he was in removal. This was in 2011. He had paperwork saying that he was actually in removal proceedings in 2007, that he had no idea that he had been in removal proceedings in 2007. So, and then he told me the story about the reason why he came to the United States. And I just did not know what the hell to do with his case, because I didn't understand what was going on, and he had no idea either. And so, but there's something about, like, you meet him, and there's just something about him. He's always happy. You know, he's sitting there in detention. He's been in detention for 2.5 years, and he's still, when you talk to him, like, I've only talked to him a couple times when I was really worried for him, but he's usually in, like, a pretty upbeat mood.
He always finishes every conversation with, "Have a nice day."
And I couldn't forget about him. And I remember I tried to call Catholic Charities in Baltimore, and I told them about the case, and I was like, I think it's a good asylum withholding or removal case based on former membership of a gang. And they were basically like, yeah, right, he's in front of Judge Gossart. Judge Gossard's not here now. Okay. That's going to go nowhere, which made me even more nervous, because I was like, oh, I shouldn't get involved in this case. But there's just something about him I couldn't get him out of my mind. So I went back to the detention center. I sat down with him for an hour and a half, and I just worked I figured out what had happened with his case. So he had applied for a temporary protected status when he initially came to this country, but it was denied, and he never followed through with that. He was picked up in 2007 for something. It could have been a traffic offense. It's kind of unclear. But the officer who had stopped him saw that he had gang tattoos on him, so the officer arrested him and connected him either with the Department of Homeland Security or the FBI. He always thought he was working with the FBI, but he could have been working with DHS. But bottom line was, he was working as a government informant. And because of his work as a government informant, the U.S. government gave him something called special parole status, where they let him stay in this country. And so they had started removal proceedings against him, but he never even saw an immigration judge, because what DHS did was they filed to administratively close those proceedings, and then he was working as a government informant and got this special parole status. And
But no one's allowed to know, right?
yeah. So, and then there was this letter.
Even know.
Yeah. Then there was this letter that he received that just said, "We're terminating your status," and DHS recalendared his removal proceedings, and he was thrown back in removal proceedings, and then they amended his charging document to add, he had received in 2007, he had received probation before judgment for possession of a marijuana blunt. And I don't know, I'm sure as everyone knows, probation before judgment is not a conviction under Maryland state law, but it is a conviction under the Immigration and Nationality Act. And because of the way they charged him in the immigration document, it subjected him to something in immigration law, there's mandatory detention. So that means that he has to remain detained throughout the course of removal proceedings, and he's not eligible for bond. So when they recalendared his removal proceedings, they tacked on this extra charge just so he couldn't get out of detention. And so I really wanted to help him. I came up with this pretty good argument to try to get him out of to argue before the immigration court that he wasn't subject to mandatory detention. I really wanted to raise this argument, but I didn't want to represent the merits of his case, the actual asylum withholding case, because it just requires so much work. So then I went to Catholic Charities in DC with another alumni of the law school. She was going to take the case, so I entered my appearance in immigration court to argue just the detention issue. But once you enter your appearance in immigration court, you're in. So I was like in for the entire case, but I had come up with an arrangement with Catholic Charities that I would just do the detention issue, and Catholic Charities would take the merits of the case. So I argued my detention issue, and of course I lost. And then and then Catholic Charities couldn't take the case because his family couldn't pay the fee. So then I really freaked out, because I was like, I can't handle this case. So I called Maureen and just begged her to take it. And she did. And so that's how the clinic became involved.
And that's when Alison stepped in.
So I was put on the case when I was in the immigration clinic as a 2L. So didn't know anything. Still kind of don't know anything. And I, along with AJ Barreto, another student, were to represent Julio at the merits hearing. Now, our tactic was that we were going to try to get this temporary protected status, and the asylum withholding claim was like a backup plan, basically. And so, we were trying to prove that he had been here before 2000, kind of all the elements that you need for this temporary protective status for when we get to the merits hearing. And on the side, we're getting things together for the backup withholding claim plan. And the night before the filing was due, we realized that, so with temporary protective status, if you have more than 2 misdemeanor charges, you are not eligible. And Julio has a lot of traffic issues, which are misdemeanor convictions in Maryland, and he is not eligible for temporary protective status. So withholding becomes our main plan. So we had a long night and, filed all our evidence, and it was my first experience going to trial and anything, so certainly there was a lot of learning along the way on how to get evidence from family members in El Salvador, incorporating documents from newspapers about the gangs in El Salvador, doing affidavits with him, just learning that whole process was important and time-consuming, and a lot of help from Professor Sweeney. So we went to the merits hearing and I think kind of knew we were probably going to lose. But it went well, I guess.
Yeah, you guys did a great job.
Yeah, it went well. We got everything kind of on the record that we felt like we needed to get on the record because we thought we probably would have to take an appeal. I guess, so then the judge said she was going to issue a written decision, which she did then, I guess, a week later or so, in which she made very few factual findings, which I guess kind of helped us.
I mean, it was one of the worst decisions I've ever seen, but it ended up helping us.
Yeah. What did she find? She basically found that he had been in a gang and that he was afraid to go back.
Right. She also found that he testified credibly.
Yeah.
So sort of without meaning to, she basically forced the appellate courts to accept everything that he testified to. So that was the part that was good for us.
Yeah, but she never found whether or not he left the gang. She never found whether or not he any of that stuff. And I think right around then was when you were arguing your habeas.
Oh yeah,
case.
I filed I tried to get him, so because my argument didn't fly in immigration court, I was like, well fine, I'll go into U.S. District Court. And I filed a habeas petition with help from an attorney in the public defender's office because I was actually kind of afraid to go into a federal court by myself. And right after he was denied relief at the immigration court level, we won the habeas petition. So we were like, solid, we can have. So our argument in U.S. District Court was basically he's not subject to mandatory detention, and you have to order the immigration judge to do a bond hearing, because that's what she wouldn't do. She wouldn't do a bond hearing. So the U.S. District Court in Maryland said, you're right, he's not subject to mandatory detention. The immigration court has to do a bond hearing. So as soon as he was denied relief, we got to proceed with a bond hearing, and we were extremely excited about it. DHS had set the bond at $27,000, which is $27,000, which is extremely high for an immigration bond, because I think you have to put up at least 15%. 15% of the actual bond, and that depends on how much collateral or equity you can put down. So we had a bond hearing, and of course, the same judge who denied him relief refused to lower his bond. And at the time, I was kind of like, whatever, his family owns their home, so I was like, he's going to be able to get out because they can just put up their house as equity. But unfortunately, they didn't have enough equity in their home, so we were kind of stuck at that point.
So Professor Sweeney, I guess the appeal to the Board of Immigration Appeals kind of happened over the summer. So Professor Sweeney kind of did that one on her own. I remember I read a couple of drafts when I was at the beach, but I didn't do a lot. Yeah, she went forth on that by herself. I don't know if there's anything you wanted to say
Yeah,
about
not
that.
really. We lost that one too.
Yeah, so we lost that too.
Though the brief was brilliant.
And when the decision came back, something that I remember when we were talking about it that struck us was like they pulled all these cases that didn't really have as much to do with like Julio's situation as a former gang member, and they were pretty easy kind of to distinguish what the Board of Immigration Appeals, well, it was pretty easy to distinguish what the cases that they were bringing up from what Julio's situation was, and they took his account as true for their purposes. So, I mean, that's great. That means everything that we presented is, like, we can use if we appeal again. So, Professor Sweeney decided to go ahead and appeal to the Fourth Circuit, and since I was doing Clinic 2, I told her that I wanted to be a part of that. And so we forged ahead and tried to figure out how to do that. There was a lot of logistical learning about how that works with appealing to the Fourth Circuit.
Alison taught me a lot about the federal rules of appellate procedure.
I spent a lot of time reading the handbook. And I mean, it was basically me and Professor Sweeney, then with advice from others that were like Emily, that were reading the brief as we were kind of writing it, that we put together this brief. And it was, I mean, a really great experience, like learning how to write better. And we went through like a million drafts, and we kind of spent most of the semester trying to put this brief together. We had an amicus, the American Immigration Lawyers Association had an amicus. We're going to file an amicus brief on our behalf, so we were working with those attorneys out in Minnesota so that our briefs would kind of complement each other, and they were giving us suggestions.
And they, interestingly enough, were working with the clinics at the University of St. Thomas and the University of Minnesota. So there were actually law students out there working on the amicus brief while we were working on our brief here.
Yeah, so I mean, I guess I don't know what else to say, but so that was, it was a really great experience, just being able to get that like feedback from Professor Sweeney on what I was doing and be able to contribute to kind of like and learning how the whole process works as far as like appealing a case goes. And that's when I graduated and left.
In that way that students have of abandoning you right at the moment of truth. Although Alison was there, I have to say, and I ended up doing the argument. The argument was scheduled in October, and I didn't feel like I could get a student up to speed fast enough because I didn't have anybody who was continuing. So I actually did the argument. And for those of you who have noticed my fancy suit, which is not how I usually dress, this is the suit I bought for the Fourth Circuit argument, so I thought I would wear it today. So we went down to Richmond, and Alison and Lauren, who I had assigned to the case, were both there. They had my back that day. That, was a great experience for me, not so much for the government attorney who didn't handle it. I've since had students listen to the argument, to her argument, as a way not to do an oral argument at the appellate level. It was really fairly disastrous. But that was okay with us. So the judges really got it. They got the fact that we weren't talking about somebody trying to get protection on the basis of being a gang member, but that it was somebody who had made the very courageous decision to leave a gang that we were trying to protect. And they totally got that from the very beginning. So the oral argument was actually just really very easy. I'm never going to do another oral argument because it will never go as well as that one did. So then I'll let Lauren talk about some of the advocacy we've done since then, which has been less defined in some ways, but as important.
Okay, so I came on in September of the 2013 after. Before the oral arguments, so I had actually worked for the Office of Immigration Litigation and DOJ over the summer, so on the other side. So I was sort of familiar with some of the, with asylum in general and some of the issues around it. So we worked during the fall on preparing for the oral arguments with some attorneys in D.C. and also the amicus attorneys as well. And as Professor Sweeney mentioned, it went great. So then we also during that time focused on the detention issue because Julio was then in December of the year before, had been transferred from Dorchester down to Etowah, Alabama, which is a really ghastly detention center. It was, on I think the second worst in the nation on Detention Watch. I think the annual cost of detaining an immigration detainee nationwide is about $150 a day per person. In Etowah, it's $40 a day. He talked about the food just being inedible, and he hadn't set foot outside in more than a year, and just really horrible conditions. So I worked with Emily, first of all, Emily knew more about the detention issue than I even had any clue about, and so we first worked on filing a motion for a bond hearing in the immigration court in Oakdale, Louisiana, which is the immigration court that has jurisdiction over Etowah. And we argued that he was not subject to mandatory detention, and that he was not in the removal period. It was a very complicated argument because he had a final order of removal from the Board of Immigration Appeals, but then when he appealed to the Fourth Circuit and had a stay of removal granted in his case, he no longer had a final order of removal. He was back in the final order of removal phase, and so that's put him, the detention authority, under a different section of the statute. And so we argued for a bond hearing in Oakdale, and they dismissed the case. They dismissed it and said they didn't have jurisdiction. So then we filed a habeas petition in the district court for the Northern District of Alabama, and arguing that he's not getting, that the immigration judge has denied jurisdiction. He has no other form of relief. This is his only recourse for being released, and he's been in detention for almost 3 years now. And the Supreme Court has said that anything beyond 6 months is presumptively unreasonable unless you can show that the person is a flight risk or a danger to society, and he's neither of those things. So we filed the habeas petition in November. It's still pending. In the meantime, ICE has suddenly said, oh, by the way, you still have a $27,000 bond, which we thought had lapsed when he had the final order of removal. And so that puts our habeas petition in jeopardy, because now they can say that he has a bond, and so theoretically is not being, could pay it and get out. But of course and then now they've reduced it to $15,000, which is still more than he can pay. So anyway, so that's pending. In the meantime, we've had a little bit of good news, which is that he's finally being transferred back to Baltimore, which is great for him, and at least he's will be closer to his family. But we're still working on that. Once he's here, we will file a motion for a bond rehearing and try to get the bond lowered to something that he can pay.
Yeah, but we're in front of that same judge
Right.
who keeps on denying relief and denying.
Right, and
lowering
so in
the
the
bond.
meantime, Lauren has been using her journalistic skills to write up some press, so we're going to try and get some media attention to it, and have been advocating behind the scenes with people in ICE at various levels, trying to get some kind of prosecutorial discretion, at least on the detention issue. We don't think they're going to give on the substantive issue, but that's okay. I'll fight that, for the next 20 years if we can get him out of jail. So we have this kind of media press to try and that we're working on, to try and get some pressure so that when we end up in front of the same judge, she will at least have maybe a Baltimore Sun or Washington Post article, putting a little pressure, and maybe some of the higher ups. So all of this, it's a long, complicated story, and we hope that we're moving in the right direction for Julio. It's great that he's coming back. So I was thinking about, well, so what makes this such a great clinic case? For the first thing I think is that it's client driven, and that's what we do here at Maryland, is we teach people to really represent their clients and to let the client be the heart of it. We ended up in the Fourth Circuit because that's what our client needed. And we're going to the press because that's what our client needs. It's also dynamic, it's changing all the time, it's multifaceted, it helps us, gives me plenty of opportunity to talk with students about the various kinds of advocacy that we have to do, the many kinds of ways that we can advocate for our clients. It's intellectually challenging. The asylum law itself that we're working on is intellectually challenging. It's we're helping to shape the law nationally on how you can claim protection based on these kinds of things. And one of the things that I really love about it is what I said at the beginning, is that it really has been a wonderful demonstration of the kinds of fruitful collaboration that we can have everywhere from our students and our alums and the public defender's office. We had colleagues from the federal public defenders help to moot me for the Fourth Circuit arguments because they were used to the court down there. We worked with the folks out in Minnesota. We've worked with the American Immigration Lawyers Association. We've worked with alums and all sorts of other colleagues trying to get ICE. And it's just been a really wonderful experience for me, as well as a way of modeling that kind of advocacy and that kind of community building with students. And that when we build that kind of community, we not only can serve our clients better, but we also sustain ourselves in the work for the long term. We're happy to take questions. I don't know if there really are any questions, but...
So I assume you got a remand as
Yes.
opposed to reversal.
Yes.
But doesn't the holding predetermine the decision on remand? In other words, if you have to accept that leaving the country to escape getting killed when you're withdrawing from a gang is a ground, don't you win?
Well, yes and no. We win. It was a very narrow holding. And there are essentially three elements to finding that it's eligible for relief, and the Fourth Circuit held on one of them. And then that decision that came out 2 weeks later from the Board of Immigration Appeals purported to hold on the other two that it was not a proper ground. So we're going to have to continue to fight.
Was that generated by this case?
This was one of the cases. This is, as I said, there are 3 other circuits that have held this, and there are cases pending in other parts of the country. But they were aware of our case. In fact, this is a great testament, I think, to everybody's work. One of our former, Hillary Skolton, whom I mentioned, is now working as a judicial law clerk at the Board of Immigration Appeals, and she overheard somebody talking about the case at the board, and they were complaining about it. They were saying that Martinez decision was just totally wrong, was horrible, and I don't know how we could have blown it that badly. But the law school, she heard them say this, the law school that handled it was really a tough opponent. So.
So, as the policy clinic person in the room, my response is, and so what's next from the big picture, Maureen and panelists? I mean, case law is one way to make policy change, but there are other ways.
There are other ways, and one of the things, Lauren and I have participated in a series of conversations. There's an asylum litigation working group, national, that is looking at lots of different aspects of asylum, but this one particular question of the particular social group, which is what we've been working on, is very hot right now, so they've had some calls that we have been involved in. There are regulations that have been in the works for a decade now, I think, that are continuing to be shaped, and so there was a lot of talk about how this might affect the regulations. Part of the problem here, and actually one of the other reasons I think this is a good clinic case, is that it's really hard to build a coalition around gang members or former gang members. We can kind of we can explain, he's not still a gang member, but in terms of the politics of it, the politics around immigration are difficult enough anyway. Then you throw in the four-letter word, and it gets really tough. Even in the conversations of this litigation working group, which is a very sympathetic crowd, the gang members were not really everybody's top concern, or the former gang members were not everybody's top concern. So it's hard to know. I think one of the reasons that this is a perfect clinic case is that we were able to put resources to defend this guy who would not have, he would have spent the last 2 years, well, I don't know what would have happened once he got there. He would have been long gone if it hadn't been for us. And for the kind of resources that we can put in without direct concern for the political fallout, although I know that's not always the case. We have not felt that. Although we did end up in the chair of the House Judiciary Committee wrote a letter to Eric Holder asking him to petition for cert in the case because they were so outraged with our decision, and actually posted it on their website. So there was political interest, but we haven't felt that here. We've been able to defend him vigorously despite that. So I don't know. It's a good question, but as I say, it's a tough coalition to build. Yeah.
So, building on that and drawing from some of the conversation last night during dinner. So my wife does work in this field as well, and when she tells me the stories of these types of cases, I'm an outsider to the world, and I get stuck at that point at which she's telling me that her client, oh yeah, and got arrested for blah 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 blah, right? And yeah, it might be a minor offense, but I think the lay public, right, hears, criminal, arrested, conviction, whatever these terms, and then the rest of the story gets lost, right? Because again, right, gang member, that's even at a higher level. But even before that, right, just, criminal arrest, conviction, whatever. And so my question is, have you guys thought about ways, and this is drawing from last night's conversation, of changing the vernacular? Are there, even the term crimmigration, which this isn't exactly that, but that's a nice academic thing. But crimmigration, putting criminal with immigration, to me, it always bothers me. I don't love that term. But have you guys thought about ways to sort of recast the whole picture and sort of create phrases or terms that make the telling of the story a little bit more sympathetic?
Yes. I never say that he's convicted because he's not convicted. It's probation before judgment. It's not a conviction under Maryland state law. So whenever I'm writing whenever I'm writing the habeas petitions or his motion for bond, I don't say he was convicted. I say he received probation before judgment. And then I do my little footnote, not a conviction under Maryland state law. He really doesn't, and the bottom line with Julio is he doesn't really, that's the only thing he really has, aside from driving on a suspended license. So it's an uphill battle for the government to argue that based on his criminal record, he's a danger to the community. I think they just go back to gang member, former gang member, and that's basically when we had the first bond hearing in front of the immigration court, the immigration judge basically said that she's not going to lower his bond because he can't prove that he didn't commit any crimes in El Salvador as a gang member. And I wasn't expecting that because I was just well, he can't prove a negative, and the government hasn't really come forward with any evidence that he has any kind of gang association for at the time it was the 12 years he had been here in the United States. So I'm actually very conscious of that. It's not too hard to do in Julio's case, as far as like his criminal record, it's the gang member that really gets us with ICE, because that's all they have to go into immigration court and say, and everyone's like, ugh.
And they've done a really good job of it. I mean, the government's argument in the oral arguments in the Fourth Circuit and some of the cases from other circuits have really confused the gang member and former gang member, and they conflate the two. And so the government's attorney in the oral arguments was basically saying, he's a gang member, he's a gang member, he's a gang member, and we're saying, no, he's a former gang member. It's a whole different, this is somebody who made the conscious decision to leave the gang. And that gets very lost very quickly when you hear gang member, the word former sort of slips out there. So I think that's a really important point, and I don't have any good answers, but
Gang escapee or something.
yeah, right. I mean, it is important to make the point that this is based on his decision to leave the gang, not his decision to join the gang.
Well, I guess also too, when speaking with people that aren't in the legal community about this, I try to contextualize it more, like less of a, this is a former gang member, and more of a, what kind of country do we want to be? Do we want to be the kind of country where someone who's lived here for 15 years and has worked, has 2 children who are American citizens?
And who was a U.S. government
Informer,
informant
yeah,
for
who
the
helped
US
investigate
government.
green card fraud. Like, do we want to just ship them off because he has a probation before judgment for marijuana and made some mistakes when he was 14 in another country? Like, I try to, I guess, phrase it in that way as opposed to, like, these are all the things he's done. More like, this is about us and not just about him. I guess it's kind of how I try to, like, change that dynamic.
Talking about communicating the idea and piggybacking on last night's discussion about forming an idea around linguistic terms or use of language or a vernacular. There's no better way to change a populist idea than to present it in a book or a movie. Something, and while this is one story, I don't know where on the continuum of unique to common it is, but it would be sort of, could be used as an example, of a bigger problem. But going back, the transfers, it just would boggle people's minds if they realized and got a step back from the chants and the signs and the hysteria around immigration and gangs and then immigrating. If you had a face and an idea and a concrete picture and a story that humanized that.
Right, and that's kind of where we're starting to put our energies is to take. He's an incredibly appealing human being.
Right.
The truth of the matter is, once you get past the labels, he just is a very appealing human being, and that's what we're trying to start to think about communicating now, because we've tried, and we've succeeded so far on the legal arguments. It's just been a really long, hard fight, and he's been sitting in Etowah, Alabama while it happens.
Two things that I see. In the end, he's been in jail for 2.5 years for PBJ for a roach of marijuana. There's a large community in this country that would be totally, I think everyone should be appalled for that. But there's a large community in particular that you can target. If you were to do a YouTube video from the detention center where he has those cards,
Oh, yeah?
I testified against criminals. I didn't want to be in the gang because I didn't agree with that. I've been beaten and almost killed, and I'm sitting in jail for one blood. Can you send $1 to this, or $2 or $5? You would get your 15,000 and farm them out. Or the core novus that you didn't get before. Can't a governor?
He's no longer mandatory. He has bond now.
Oh, now he's
So
bond.
yeah, that's a good idea though, to
But
raise money.
He's on bond because of that PBJ.
He's on bond because not just the PBJ. It's like it's a gang thing. No, I like that.
Yeah.
We should try to raise.
Yeah.
I like that idea. Cards. Yeah.
Or I'm sorry from the governor. I don't know, I don't know very much from the law.
That's an interesting idea.
Please just don't have him say he was an informant while he is still incarcerated. That is,
Oh, yeah.
Yeah,
Not
that's
good.
a good point.
Yeah, oh yeah, exactly. Exactly.
He
Started on that.
Yeah.
What was I gonna
Someone else did suggest a Kickstarter campaign. I don't know how to, I don't know how to do that, but it is a good idea.
You know, you saw recently the young lady who wanted to find her mother, and she put something on YouTube, card saying, "I was abandoned."
I like it.
So I think that's all we have. Thank you very much.